Hello, everybody. Welcome back to Patriots History. We've been going through the Constitution, and today I think we're going to wrap up the Constitution and get into the Bill of Rights, which is, of course, is part of the Constitution. Big news, we crossed the Rubicon. We started writing checks to make Patriots History into a feature film followed by a series of videos. We're there. We're going to do it. Now we've seen the life and death of Jesus, Passion of the Christ done, huge success. We've seen a movie on child trafficking done, Sound of Freedom, huge success. This is the next step in the progression to restore pride and truth in American history. And our motto for the film process is the history you always knew, but forgot. So help us out. Go to thewildworldofhistory.com and buy Larry a coffee. Coffee's only $5. You can afford $5 out of your budget. If every single person on Twitter, every single person who watches my videos here bought me just one coffee, we'd be able to make the first series episode. If everybody bought me 5, we'd be pretty close to making half the movie. It's not going to be cheap. I don't expect it will, but we'll get there. All right. Let's get started. So, United States Constitution, Article 6, Debts, Supremacy, Oaths. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. Good deal. If you ever want to get a loan, you better pay off your old loan. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in this Constitution or laws of any state to the contrary notwithstanding. So this is the authority of the United States. Now, I went over this before, but it's important. I want to hit it again. We had some theological discussions with a pastor friend of mine who was of the opinion that unless it's something absolutely directly in contradiction of the Word of God, you got to do whatever the government tells you to do, because of Romans saying that all government is given to us for our good. And I pointed out that in Paul's time, they did not have such a thing as a democracy where people are the government, or a democratic republic, and that we have established our highest form of law. Our authority is not a person, it's this Constitution. And whenever anybody is in violation of that Constitution, we have a right, nay, an obligation to rebel and to set it straight. As Jefferson said in the Declaration, to abolish the old form of government and set up a new one in line with protecting those rights to life, liberty, and pursuit of happiness. So my sense is that if the federal government, whether it's the Congress or president or whoever, is acting in defiance of the Constitution, that we are not Bible bound, honor bound to follow him or them in any way, shape, or form. That's just my take. I'm not a preacher. All right. The senators, representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both the United States and several states, wait for it, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. Once again, the Constitution is our ruler. It is our emperor. It is our earthly king, not a person. And whenever you run afoul of that, you no longer can elicit support under this Constitution. Article 7, ratification. The ratification of the Constitution of the United States, the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. Done in convention by the unanimous consent of states present 17th day of September in the year of our Lord 1700, and 87, and of the independence of the United States of America the 12th. In witness thereof, we have hereunto subscribed our names. George Washington, President and Deputy from Virginia. In convention Monday, September 17, 1787, present. States of New Hampshire, Massachusetts, Connecticut. Mr. Hamilton from New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, Georgia, resolve that the preceding Constitution shall be laid before the United States in Congress assembled, that it is the opinion of this convention that it should be afterwards be submitted to a convention of delegates chosen in each state by the people thereof, under the recommendation of its legislature for their assent and ratification, and that each convention assenting to and ratifying the same should give notice thereof to the United States in Congress assembled. Resolved that is the opinion of this convention, that as soon as the conventions of the United States shall have ratified this Constitution, the United States in Congress assembled should fix a day on which electors should be appointed by the states which have ratified the same, and a day on which the electors should assemble and vote for the president, and the time and place commencing proceedings under this Constitution. That after such publication, the electors should be appointed and the senators and representatives elected, that the electors should meet on the day fixed for the election of the president, should transmit their vote certified, signed, and sealed, and directed as the Constitution requires to the Secretary of the United States in Congress assembled, that the senators and representatives should convene at the time and place assigned, that the senators should appoint a president of the Senate for the sole purpose of receiving, opening, and counting the votes for president. Again, the person who receives and counts those votes doesn't have to count them. He doesn't have to accept them. He could say, these are fraudulent votes. I shall not accept them. Without delay, proceed to execute this Constitution by unanimous order of the convention. George Washington, President. W. Jackson, Secretary. The Bill of Rights, Article 1, not ratified. After the first enumeration required by the first article of the Constitution, there shall be one representative for every 30,000 until the number shall amount to 100, after which the proportion shall be so regulated by Congress that there shall not be less than 100 representatives, nor less than one representative for every 40,000 persons, until the number of representatives shall amount to 200, after which the proportion shall be so regulated by Congress that there shall not be less than 200 representatives, nor more than one representative for every 50,000 persons. This original Article 1 was not ratified, I think largely because the delegates did not want to be hamstrung as to the total number of representatives. And so they kind of kicked the can down the road and said, we'll deal with this at a later time. Article 2, 27th Amendment, ratified 1992. So they wrote this back when, but it was only put into action in 1992. No law varying the compensation for the services of senators and representatives shall take effect until an election of representatives shall have intervened. In other words, you can't supposedly change the pay you're getting while you're in office this time. You can change the pay and then get it when you're reelected. Article 3, the First Amendment. So this is the First Amendment as you know it to the Constitution. You can probably quote much of it. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. By this they meant political speech, especially, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So, free speech. Back in the 2000s, Senator John McCain of Arizona, someone I detest, was constantly going on about political action committees and PACs. A political action committee gathers together donors and bundles donations for politicians. The value is that all sorts of small money people, say like myself, can kick in small amounts of money, and with this PAC, it can have some impact. literally, the Constitution says money is speech. That if, for example, you're not a great public speaker, or if you can't write, how do you get free speech? The only way you get it is through buying advertising, especially in campaigns. Well, you don't have enough money to buy massive television ads, so you can go in with a PAC. So thank God the Supreme Court struck down the McCain-Feingold bill against PACs. I know we don't like PACs because many of them are nuts and they get out of hand, but it is the only way small donors, especially people who, as I say, don't have great speaking voices, can't do speeches, aren't great at writing, don't have a lot of money, it's the only way they can vote with their money in these PACs. So Supreme Court was right. Article 4, which now is the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, all the anti-gunners hang out on that first phrase, a well-regulated militia. The fact is, the militia was always, repeat after me, always seen as an alternative and a counterbalancing force to the standing army. Our militias, remember, we were British. The British had a standing army, we had militias. Militias were viewed as necessary to keep governments in line. And this goes all the way back to the 1100s, when you get to Henry II, I think it was, who issued the Assize, could be Assize, A-S-S-I-Z-E, the Assize of Arms, in which he basically said in a number of articles, every Englishman must be armed. And if you're not armed, it's the duty of the mayor to come around and make sure you're armed and give you weapons if you're not armed. Folks, this was a reverse gun buyback. This is, hello, Henry, do you have any guns in the house? Well, no, sir, I don't. Good, here you go. Take some of ours. Here's some ammo. That's what they would do. And this went through Henry's time and all the way up through the Whig. Remember, in earlier lessons, I talked about the Whig influence. Private arms ownership is very much a Whig idea. And there was a book written, what now? I lose track of time, 25 years ago, called Arming America. I may be mispronouncing this guy's name, but it was by a guy named Michael Belisles or Belisles. I don't know how you say his name, don't care. He was totally wrong. And the book won prizes. It won National Bancroft Prize in History and all that stuff that I will never win. Okay, great history. Oh, wonderful. And his take was that Americans weren't very well armed and that the gun culture came about much later and was never a part of American history. And he was from Emory University. Well, some people, including people who weren't particularly pro-Second Amendment guys, but just good scholars, started to look at his research and his sources, and they found this guy was full of poopy caca. He had sources to archives that didn't exist. One of his sources was to an archive that burned down before he was even alive. Stuff that he did cite simply didn't say what he said. He was a liar. And Emory fired him, as I recall, and Bancroft Prize demanded the prize back. But the scholars, the academicians, took this guy apart, and the whole notion that America wasn't armed. We were armed to the teeth. As in the movie The Patriot, virtually every 12-year-old kid could shoot. Almost all women could shoot. What did they do when the husbands were away hunting often or out in the field all day? I mean, everybody could shoot. Now, I'm not saying that they all walked around with pistols on their hips, but everybody had at least one musket at home and usually several. Everybody had their own flints, their balls, their powder. So this idiot notion that the militia clause defines the rest of the Second Amendment is simply wrong. What defines the Second Amendment is the very last phrase, shall not be infringed. Now, reasonable people can disagree about what the word infringed means, or bear arms. This has been a big deal among courts. What does it mean to bear arms? And generally speaking, the Whig context of this, agree with it or not, was a weapon that one man could hold and fire by himself. I don't think this phrase meant you should have a tank. I don't think it meant you should have a multiple rocket launcher. Certainly don't think it meant that you should have a suitcase nuke. But it does mean that as long as you could hold it and fire it, you're pretty well good to go. And that would certainly include everything they call assault weapons, which are so badly termed, it's ridiculous. Now, churches back in the day, I know some of you don't want to hear this, I'm sorry. Churches back in the day often prohibited firearms in churches. There were various towns that prohibited bringing weapons into town, not too many. Especially as we got out west, some towns tried to do that. You remember the scene in Tombstone where Wyatt Earp and Doc Holliday tried to ban guns from Tombstone. That didn't go over so well. But basically, the term shall not be infringed means for any normal circumstance that you could imagine, you have a right to self-defense. You also have a right to a weapon as a means to protect you against the government. Okay, now, schools, like I said, there were churches that prohibited this, and the founders knew that. So what have the courts said over time? Over time, the courts have generally come down on the side of shall not be infringed. The Heller decision in the mid-2000s, and I'll get to that later when I get to that point in history, said that this is in fact an individual right and not a militia right. So the Supreme Court knocked that one out of the court. More recently, the Bruin decision said that New York City could not use transport laws to keep you from being armed. As I recall the case, the guy was bringing a gun to a gun club or something like that, and the city was trying to say that he didn't have a right to transport it. And the city withdrew the case. But even though it was moot, when it reached the Supreme Court thought it was such an important case, it ruled on it anyway. And Justice Thomas wrote the opinion, as I recall these details. Again, I'll get into detail with it when I get to these many weeks down the road. But as I recall, Thomas expressly cited the 14th Amendment and the necessity of Black people owning individual firearms to protect themselves against lynch mobs. Of course, liberals didn't like that one at all. So that's the Second Amendment. Article 5, which is now our Third Amendment. So remember, 2 of these were kicked out. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Now, it's coming. Massachusetts just today announced they wanted residents, they requested residents to take these illegal alien criminals into their houses. Right now, it's just a request, but you watch, it's Massachusetts. They will get around to mandating it. And when they do, I think this article, the Third Amendment, will be incredibly applicable, because even though these are not soldiers, the intent was that the government cannot house or quarter people in your private house without the consent of the owner. You watch, see if I'm right on this. Article 4, the Fourth Amendment, I'm sorry, Article 6, the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. I think what happened to President Trump and Mar-a-Lago very much will be addressed by his legal team in this Fourth Amendment. Article 7, the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war, public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So this is the Fifth Amendment. This is basically what leads us to the Miranda decision that says that you must be read your rights and reacquainted with the fact that you do not have to give testimony against yourself. You do not have to talk to a law enforcement agent. I'm just telling you what I hear from defense attorneys and former prosecutors. If you're arrested, don't say nothing. I want a lawyer. Those are the only 4 words that should ever come out of your mouth. I want a lawyer. Article 8, the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Has that happened with the Patriot Day J6 defendants, I wonder? You think they've had speedy trials? By an impartial jury of the state and district wherein the crime shall have been committed. Do you really think they've had an impartial jury? Do you think that one of those people would have been convicted if, say, the proceedings were held in Idaho, South Dakota, Mississippi? Which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Article 9, the Seventh Amendment. In suits in common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. In other words, in property cases, you still have a right to a jury trial if you want it. Article 10, which is now the Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Folks, I submit to you that what has happened to the J6 defendants, Patriot Day defendants, is cruel and unusual punishment. They've not had speedy trials. It's just been horrible. The conditions in their jails that people have described are outrageous. So anyway. Article 11, the Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So we're moving to this thing that anything not covered in this document is ours, that we control it. In Article 12, the 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So another way of putting this is the people are sovereign. We in America, we the people are sovereign, and we ordain and establish the Constitution of the United States, which is our government. The people in Washington just carry it out, but that's the government that we answer to. All right, there's still more amendments that were added later, but we will take them up in our next session. And so I will see you guys back here on Friday.